Minister, I read with interest yesterday your commentary regarding populist politicians, your tut-tutting that the state couldn't withstand the modern penchant for jettisoning rules of due process for short-term political gain. And I have to hand it to you, you have some neck to say something like that and to come in here with which is something that is probably the worst example of a political soap opera being played out at the expense of the common good, the consequences of which will go way beyond your schemings at cabinet table. I think the issues are far too important to be used in this way, and I frankly find it disgraceful. Let's be clear here. We don't need this bill. We already have a judicial appointments bill which has gone through second stage in this House with cross-party support. I'm frankly a bit sick of talking about judicial appointments. Second stage, pre-legislative scrutiny, my office doing mountains of work to prepare amendments to Deputy O'Callaghan's bill, which at the 11th hour was pulled because of no money message. And now, on the eve of the Dáil summer recess, any amount of time is being given over to deal with the bill when the courts themselves are going on holidays in a few weeks' time. And when, after the appointments ye made to the High Court and the Circuit Court, in some instances for vacancies which will not arise until later this year. It's an absolute joke, and the only conclusion you could draw from that is the reason it's been done is to offset the damage of your botched handling of the appointment of the former Attorney-General to the Court of Appeal. But we have a responsibility to say at what price. Undoubtedly, if this process continues to be rushed in the manner in which it is, it's going to undermine confidence amongst the judiciary and amongst the public. But more than that, and Deputy Wallace is correct, and I saw you making gestures, but you know that the Taoiseach approved to prioritise through Cabinet the movement of the Coroner's Bill. And I know you sent me a letter saying you supported it as well. But frankly, the Department of Justice was told to work with us to have that bill published 2 weeks ago, and it needed to be so to pass through all stages prior to the summer recess. Now, I hope to God that no woman loses her life in our maternity services in July, August or September and has to fight the HSE for an inquest, because, by God, this has been a priority of the Justice Committee and it has been sacrificed because the officials were used to draft this bill, and I frankly don't think that that's good enough. Now, I think it's debasing, actually, a worthy objective, which is judicial reform, and I think the manner in which it's been handled actually has undermined the bill itself. Now, briefly, in terms of membership of the Appointments Commission, specifically the idea of the lay majority and the lay chairperson, well, we've already tabled amendments to Deputy O'Callaghan's bill to that effect, so we're obviously supportive of that position. But like Deputy Wallace, I would raise my eyebrows at the presence of the Attorney-General on this. I don't see any particular expertise that the Attorney-General could offer to this position. It's worth saying as well that, at least in the initial stages, the judges on this body will come through a political patronage system. I think there are political differences here emerging in the debate which are worth having out. I mean, having a lay majority on the Judicial Appointments Commission, I think we have to say, is not about one in the eye for the judiciary or the legal profession. I don't actually see it like that. It's about a particular view that you have of what the judiciary is. And people with a legal background see the appointment of judges as a career move within a system. So understandably for them, it's something that they believe should be controlled by their expert peers. That makes sense. But for ordinary citizens, they view things quite differently. They see the role as a social role, acting in the interests of society and the administration of justice, with secondary considerations being, if you like, the adherence to the legal profession. And in that basis, I think it makes sense for judges to be appointed from the society that they represent. And I think that's absolute, and being alive to its needs, I think that's very critical. So having equal representation on the Appointments Commission, I actually do think is the best way forward of giving both sides their due. But there's a problem here. I mean, Section 15 of this bill deals with experience that people who should be appointed as lay members of the Commission will need to demonstrate. Now, I am shocked to see that the initial heads of bill, which said that that experience should be in voluntary community or social affairs, has now been axed and replaced with expertise and experience in commerce, finance or administration. Now, how in God's name has experience in commerce or finance got to do with the appointment of judges? It's actually far more important having people on the Appointments Commission with experience on the ground, people who deal with communities who are likely to appear before the courts, who are ravaged by, in many instances, criminal activity, who understand the issues that lead people to have a conflict or end up before the courts with a crime or whatever. So I think that's really a retrograde step. I think another retrograde step is the provision in the original heads that the membership of the Commission should be gender balanced and reflective of social diversity. That's disappeared, and I think given the experience of women in particular, maybe at the hands of some of our courts, if anything is needed, it is certainly that area will be looked at and reinstatement. And I think the whole area of the proposed Senior Judicial Appointments Advisory Committee is an absolute joke as far as I'm concerned, made up of the Chief Justice, the Attorney-General and the Chairperson, and here of course the language is not entirely clear. Maybe the Minister is on that body. And I think Deputy O'Callaghan's section 23 on senior appointments in his bill is actually far more sensible than the suggestion that's posed here, because the original bill empowered the Commission to make a recommendation to the Government for such senior appointments to be based on merit. In other words, on the same principle as all other judicial appointments. The make-up of this Senior Judicial Appointments Advisory Committee is actually too political, it's unnecessary, it sidelines the Commission from the important appointments, and there is no clear reason why the Commission as a whole can't perform this function and why the Minister has to get involved at all. So we would see them as fatal flaws. But I have to say I am kind of sympathetically inclined to those who contributed to the debate to say that in many ways this is a false debate and it's been hyped up and it's much ado about nothing in some ways, because the key problem for citizens is not actually judicial appointments, but it's citizens' ability to access and achieve justice in this state. And that task is far bigger than judicial appointments. I have to say I would be broadly sympathetic of those who say we have some outstanding characters in this state and individuals who serve the judiciary remarkably well. I find myself going to courts quite a lot, and on many occasions I'm absolutely gobsmacked by the calibre that's there. It's incredibly impressive. But when it goes wrong, and those judges are not up to scratch, it goes very, very wrong, and there is absolutely nothing we have in place to deal with those individuals. And in actual fact, legislation for a judicial council is in far more urgent need than what we're dealing with here. And but it's not good enough that we're rushing through this. This has been on the cards for a long time. We know, and it's an open secret, that we have a judge in one of our district courts who, realising the shortage of people, the need for judges who would speak Irish, put himself forward on the basis that he could speak Irish. He didn't have a word of Irish. He got the job on that basis, but of course once he was in it, having lied to get in it, there was nothing that they could do. He was still there. We know that the family law courts, on a daily basis, terrible things are going on behind the scenes, lives being destroyed without any proper scrutiny or legislation, and we need an urgent intervention and oversight of our court system. I mean, I desperately want to see judicial reform, but proper, comprehensive reform. And in the present form, this bill definitely isn't it. And we're doing a disrespect to the good members of the judiciary who are out there, to the members of the public, to the citizens who are going to come before our courts, if we go through and use this issue as sort of political capital or some sort of a political game. Because, to be honest with you, the issues are far more important than that, and I don't want to be part of something that debases a very important objective in this way. I think it leaves a hell of a lot to be desired.